Hi, Darin Mangum here, the PPM attorney. One question that I get sometimes from clients is, what's the legal basis upon which I can actually sell my securities without being either a registered broker-dealer, without being a securities licensed person? In other words, do I have to be licensed with FINRA to sell my offering? And that's a very good question. It's a very critical question, not only for those of you that are just raising capital for your own company, but if you're running any kind of private investment fund, private equity fund, hedge fund, whatever, those are certainly critical things to think about. So the definitive rule on this, and there are a lot of state rules that mesh and correspond with this rule, but Rule 3a4-1 of the Exchange Act of 1934 provides a non-exclusive safe harbor, and that means, hey, as long as you abide by this rule, then we're not going to deem you a licensed, an unregistered rep or an unregistered securities salesperson or something like that, right? As long as you abide by this rule, you're in the safe harbor, and we're not going to come tag you. The SEC is not going to come tag you. FINRA is not going to come tag you, right? So basically, what Rule 3a4-1 says is if you're an associated person of the issuer or associated person of the company, meaning an officer, director, partner, manager, you're basically helping run the company, you're deemed an associated person for that reason, and you're able to actually represent the company to investors because you are in that capacity as an officer, director, partner. You're basically helping call the shots, running the company, and so you can certainly represent the company's securities offering to investors, right? But you certainly, just being an officer, director, partner doesn't mean you're in the clear. You also cannot, number one, you cannot have been disqualified as in some prior securities infraction, and that happens sometimes. People, they have what we call permanent bars or permanent cease and desist that are, hey, you can't raise capital for any reason in the future. I mean, that's certainly a disqualifying act that certainly would prevent you from doing that. So obviously, if you're not a disqualified person, if you're also not if you're not a registered rep that's associated with a broker dealer, so again, you can't go, you can't be like a licensed security salesperson and then just say, oh, hey, I'm going to go and be an officer or director of this company and help them raise capital. No, you can't have done that, and you can't have done that within 12 months, prior to the offering. Okay, so again, this prevents salespeople, securities licensed people from essentially just jumping from one company to another, helping them raise capital and then moving on. Okay, that can't, and it also can't be your primary role at the company. I mean, it could be certainly a main focus because if the company is a startup, like the CEO, right? They're always raising capital. They're always talking about it, but that's not their primary function. It could be a major function, but it's not your only job that you're there. You're not just a hired gun to raise money and then you're off again. I mean, you have to actually have legal authority and other responsibilities. Again, as a legitimate, bona fide officer, director, partner, however you're set up, and so. Those are some things that allow you to rely upon Rule 3a4-1 of this Exchange Act, and again, that's done. It's done all the time when it comes to raising private equity or private capital, and it's done all the time when you're, say, if you're managing a private investment company, pursuant to an exemption under the Investment Company Act, certainly that comes into play there as well, right? And I don't know if I mentioned you can't be paid a commission either, as an officer, director, partner, manager. You can't. If I sold some stock in the company, I can't just put in my pocket a 5%, 10% sales commission for doing that. No, that's you can't be compensated directly or indirectly in connection with that sale. I mean, certainly you could be paid in the ordinary course of the business as a salary for doing things other than raising capital, like obviously different functionary things that you would do in that in helping run the company, but you can't collect a commission either. So that's a broad overview of this super important rule. Again, as it applies to your particular situation, happy to have you give me a call. I can certainly talk to you about it and make sure that you're certainly in compliance, because it is an area where entrepreneurs do get tripped up all the time. They're not fully aware. They may be aware of a piece of the rule but not others, and they're you just have to be aware of the full gravity or the full capacity of the rule and comply with that, just to make sure you don't get burned, again, either by a state or federal regulators in that capacity. So anyway, again, that's a common question that I get. Feel free to give me a call and chat about it. Again, thank you for watching. Hopefully these videos are helpful, and we'll see you on the next video. Thank you.